Without further ado, let's get going. This is Miller Johnson's second installment in our Lessons from Litigators Webinar Series. And today we're going to be talking about Michigan's new no-fault law, what you need to know when renewing your own auto insurance policies. My name is Joe Gavin, and with me is my partner, Dick Hillary.
Hello.
We are, we'll talk a little bit about our background here briefly, but the bottom line is we are counselors and litigators in this space. And hopefully we can add some value for you folks as you're thinking about your no-fault policies going forward. Just so everyone's on the same page, we are not your attorneys right now. This is intended to be informational only. It's not intended to create a lawyer-client relationship. And before acting on the basis of any information we're giving you today, we'd encourage you to consult with a lawyer, whether it's us or anybody else, because your specific situation is going to require its own unique analysis under the circumstances. So as I said, today is about Michigan's no-fault law. We're going to be going over the who, what, when, where, and why of renewing your auto policies and beyond that, and kind of talking about what the ins and outs of no-fault are. We'll start off by giving sort of a brief background and then getting into some more details. First question, I'd say, is who are we? And I'm going to invite my partner, Dick, to kind of give his brief bio, and I'll tell you a bit about myself. So, Dick.
Good morning, everybody. My name is Dick Hillary. Welcome, and thanks for attending. Normally, we do these mid-afternoon, so this is a little bit earlier. We're happy everybody plugged in this early, and we see we've got a decent number of people, so that's exciting for us. I am a commercial litigator here at Miller Johnson, and I primarily practice in the area of medical reimbursement or healthcare reimbursement. And the most significant piece of my litigation is in the area of auto no-fault law. I'm also a consumer of Michigan automobile no-fault coverage, like you all are. And so I've had to, for purposes of this presentation, Joe is exactly right. We are not your lawyers here today, but for many of you, we are, and we have a client relationship already. But the advice and counsel, to the extent we give any today, understand it's the very same advice and counsel I've given to myself, to my loved ones, to my adult children, to my parents. Auto no-fault has become very complicated over the last year, and the renewal of our policies is also very complicated. So we're going to give you some insight into what we've really told our friends and family when they've given us phone calls. So thank you for plugging in, and take that for what it's worth.
Thanks, Dick. And just a brief bio on me. I'm also a commercial litigator, and I also specialize in healthcare insurance litigation. Been doing this, my goodness, for 14 years now, and focus on health plans, some risk litigation, and a lot of automobile insurance disputes. So between us, Dickie and I have probably more decades of experience than we care to admit, but in this space. So thank you as well for attending this morning. As I said at the outset, we're going to talk about specifically Michigan no-fault in this presentation. And just to give you a brief sort of primer of where we're going, give you a summary of and an overview of the no-fault system in Michigan, because it's sort of a unicorn in many respects. Then we're going to talk about what has changed more recently, what some of those changes have been in the last year and a half, and why those changes may matter to you. How this may affect your insurance policies and choices that you have to make. And then we'll close with some general thoughts on what to do if you are involved in an accident, just at a high level. So digging right in, I guess the first question we have to answer is, what is Michigan's no-fault law? Well, the bottom line is that it's intended to be a comprehensive legal scheme that governs auto accidents in Michigan. The basic idea is that with no fault, you get coverage, and it doesn't matter who caused the accident. That's the no fault piece. Now, in exchange for that, the courthouse doors are partially closed to you as at least to the person who may have caused your accident. And that's sort of gets me to a bit of history here. And without getting too far into the weeds, this current system distinguishes, if you go far enough back, how we used to do things. Used to be the case that if I were driving my car down the road and someone hit me, we solved the damages that arose from that incident through what we lawyers call a tort-based system. It essentially meant that I could recover whatever my damages were, if I had medical expenses, if I had other harm to me, if I had to miss work, whatever the case may be, I could recover from the at-fault driver, the person that caused my accident. And then that all changed. Now, some states still do that. And in many respects, as you'll hear today, we sort of have now gone back to a modified tort system. But going back for when the legislature first enacted this scheme, and that was back in 1973, the purpose was to sort of fix those problems, because what you ended up having were long delays, inequitable outcomes. People would have to often litigate in order to get their medical bills paid. People would find themselves subject to collections, lawsuits. And if you happen to be hit by someone who was insured, you got your damages recovered. But if, heaven forbid, you weren't, and that person didn't carry insurance, then you were out of luck. So the legislature came up with this no-fault system as a compromise system to kind of fix some of those inequities that were inherent in the old system. That leads us to kind of what the basic structure of the current system is. It's what we call first party and third party. Now, essentially, what that means is for first party, you being the first party, the individual who procures and buys your own auto insurance, you will look to your own insurance carrier for certain benefits if, heaven forbid, you're injured in an accident or if someone you love is. Alternatively, third party is sort of a separate system that is only available in a limited class of cases if you meet a certain threshold, and we'll talk all about that. And those kinds of cases are historically designed to provide compensation for traumatic injuries, lots of pain and suffering. So, and we'll talk a little bit about each one of those. So just first party benefits. Let's get sort of the basic idea in mind. What do you get as part of a first party benefit? What do you get from your own no-faulting carrier if you are, in fact, injured in an accident? Well, you get several things. You get, let's see if I can get this PowerPoint to work. There we go. You get your medical expenses paid. So if, heaven forbid, you end up in the hospital, your own insurer is responsible for paying your medical expenses. You get wage loss. So if you have to miss work, because of your injuries, you get a certain number of years, frankly, up to 3 years of wage loss coverage for your expenses. Attendant care services. That's the kind of thing where if you are traumatically injured and you need help at home, you need a nurse, you need things like bathing assistance, you need that kind of personal care because you're unable to do it, the no-fault system will provide benefits and coverage for that kind of thing. You also get replacement services. Replacement services are those things that you used to do around the house that you're not able to do. So if you were like me, somebody who mows the lawn or tries on occasion to help out around the house, then if I'm unable to do that, I'm going to be able to seek somebody else to step into my shoes, and the no-fault system would pay for that service. In the rare case, their funeral expenses are covered and there are survivor's loss benefits. These are all things that you would get without having to go to court. You'd look to your own insurer to get them for you and provide you compensation for those kinds of losses. Now, let's turn to third party, because that's a sort of different animal. That's where things get really bad. It's what we call, did you suffer a threshold injury? There are certain types of injuries that our legislature has said are so significant that we're not going to close the courthouse doors to you. You're going to be able to look to the injured driver, the at-fault driver, the person who caused your injuries, and this is the fault of no fault, so to speak. You're going to be able to look to that individual and say, he owes me compensation for historically, it's been things like pain and suffering and certain other limited damages. If you had suffered this threshold injury we talk about is something that's fairly high bar historically. Death, serious impairment of body function or permanent serious disfigurement are things that you have to have suffered in order to have the courthouse doors open to you for these types of claims. And this is really the compromise that our legislature struck. It says you can make a claim with or sue the at-fault driver only in this limited class of cases. And in exchange for the more minor or more routine accidents, you're going to provide, or your insurance is going to provide you with these basic benefits. And that way we have, in theory, and hopefully less litigation, less inequitable resolution disputes, and the system works better as a whole. Which leads us to 1973, which is where we started, 2019, which is when our legislature made some recent changes to our system. And today, what has changed and why does this matter to you? At this point, I'm going to turn it over to my colleague. Am I early or no?
You're fine.
Okay.
Yeah, you're fine. So thanks, Joe. So the changes to our Michigan no-fault law that we have experienced over the last year and are now phasing in and almost nearly all in effect are, to say the least, dramatic. And Joe discussed the first party, third party dynamic that we have under Michigan no-fault law. We will experience significant changes and have on both pieces, first party changes and third party changes. The most significant change that we need to be aware of, for nearly 40 years, we have had a guarantee in Michigan for unlimited, lifetime, uncapped medical benefits. Many people do not know and do not appreciate that the most important medical insurance that you carry is attached to your auto policy. Until I began practicing in this area, I did not fully appreciate or understand that. But all of our auto policies carry a medical insurance component. It's also the most expensive part of our auto policies if we were to break down the premium allocation for the insurance that we cover. Today, if you haven't renewed, and you will, or if you've already renewed, you now have a choice. You can choose less than guaranteed unlimited lifetime medical benefits, and you can do so for a lower premium. There are serious consequences if you do that. And as we go through today, we're going to talk about some of those. I will share with you what I've purchased in auto insurance, and you can take that for what it's worth. So the most fundamental change that we now have on the table, we can now, as consumers of insurance, of auto insurance in the state of Michigan, decide that we do not want to buy insurance that provides unlimited lifetime medical benefits. We are now given the option to cap that coverage at a certain amount.
Let's stop there for a second, Dick, and just highlight one point. I think that there's something I mentioned earlier on, the idea that Michigan no-fault is kind of a unicorn. And I think the idea that these benefits would attach on an unlimited lifetime basis is something that really bears repeating. Because that kind of benefit, that kind of coverage is somewhat unique in the marketplace as far as I'm aware. And it's something that we routinely see in other jurisdictions that don't have that kind of coverage. Benefits get exhausted, and we'll talk more about that. But I just wanted to highlight that point because I think it's an important point that we'll talk about.
Right. Many commentators have referred to our no-fault system, particularly the medical component piece and the unlimited lifetime medical benefits, as the Cadillac of healthcare coverage in America. As you'll see, some consumers now will be able to buy a 1953 barely running Pinto for their medical coverage, and we will encourage you to buy a nicer car if you can. Another critical change that we see, and this really has a couple of different components, but under the old law, auto would pay and could be set up to pay your medical benefits as the primary payer after every auto accident. And if we were counseling you under the old law, we would insist upon all of our clients ensure that their policies had auto as the primary payer. Today, you can even, in certain circumstances, opt out of auto no-fault medical coverage altogether and shift the responsibility for paying your medical expenses after a motor vehicle accident to other potential payers in the system, including a health plan, if you are covered by a health plan, Medicare, if you're eligible for Medicare, or even Medicaid. Under the old law, your service providers, your medical providers, the hospitals, doctors, nurses, rehabilitation specialists, post-acute care providers for you and your loved ones were entitled to bill their actual charges for their care and treatment of you, and no fault insurance was obligated to pay those charges so long as they were reasonable. Today, actually beginning in July, in just a few months of this year, your service providers are no longer going to be able to recover their actual charges for treating you. There will be what we call here on our slide a fee schedule, which is in reality a fee cap. The amount that your doctors and nurses and rehabilitation specialists will be able to recover for treating you from your auto insurance will be capped. And these caps are significantly lower than what your service providers were entitled to recover under the old law. And finally, we'll touch upon this at the end of the presentation, but there was very little opportunity under the old law for the auto insurance carrier to involve itself in your medical care and treatment. Decisions with regard to how you were treated, at what level you were treated, were left where, in my judgment, they should be left with your treating physician. Today, under the new law, the auto insurance carrier has been given greater power in its ability to involve itself in the level of care that you are receiving. That power is manifested in changes in the law that will permit your auto insurance carrier from paying your service provider if it believes that the services being provided to you or a loved one after an auto accident are either too expensive or really delivering care at a level that the auto insurer concludes is a level greater than what you actually need. That is a significant change in how the law operated for nearly 40 years. So with these changes, there are winners and there are losers. One of the winners is the consumer. Joe, you, and me are all going to, in theory, and really more than in theory, because I renewed my policy and experienced it, we will be paying premiums at a lower amount than what we had previously paid. That is a fact, at least in the short term. But you get what you pay for. And if you're paying less, those of us in business understand you typically get less, and that's exactly what's been balanced here. So getting to kind of the next two slides, the meat of what you are going to see when you renew your policy, or if you've already renewed your auto no-fault policy in Michigan, what you've seen. For the first time in the history of auto no-fault in Michigan, you will be given a choice in what level of coverage you want to carry on your policy. I'm going to talk about these choices in order, and they're not necessarily in the order of the slides, but I want to go from top down, from what I would describe as the best coverage you can purchase, and then tick it down really to what I would say is the worst coverage you can carry on your policy. You can still today elect to carry unlimited, lifetime, uncapped medical coverage on your policy. Your insurance carrier is obligated to offer that to you when it sells you insurance in Michigan. That choice is still yours. That guarantee that was in place for 40 plus years is still an option for you to choose on your policy. But you can step down from that. You can decide you want to cap that coverage at $500,000. And that decision, if you make it, will result in a lower premium for you. You can step down even further and decide to cap that coverage at $250,000. Again, there will be a related premium reduction if you make that decision. Some consumers can even elect to cap their no-fault coverage at $50,000. In order to do that, the insured on the policy has to be covered under Medicaid in our Medicaid system, and the spouse of the named insured and relatives who live with the named insured also need to be covered by Medicaid or carry some other type of insurance that would cover a motor vehicle accident. If this $50,000 Medicaid cap is elected, it applies to the named insured and his or her spouse and any relative who lives with the named insured. Now, as I've indicated, the premiums will fall commensurate with the level of coverage that you decide. But what I would say is don't go spending your savings on a shopping spree, because with these capped coverages come very real and serious consequences. In our experience, a lesson from a litigator that we can pass on: any serious motor vehicle accident that involves any serious injury to you and your loved one will very quickly reach these caps. And once these caps are exhausted, then it's on you to pay the difference. And most of us, and in many cases, I would think it would be fair to say none of us could afford to pay the medical expenses that result from a serious traumatic brain injury. So premium reduction, yes, consequences are huge. There is also an ability when you make your election to opt out of no-fault coverage altogether. So on the earlier slide, we talked about capped coverage. On this slide, there is an ability to not carry any auto no-fault medical coverage on your policy in exchange for a premium reduction reduced to zero. These exclusions from auto coverage really apply to two categories of claims. The first is what we refer to as the qualified health coverage exclusion. If you carry health insurance that covers automobile accident injuries, and everyone in your household, including your spouse who's related to you, also has qualified health coverage, you can choose to essentially set your qualified health coverage up as the primary payer and exclude PIP altogether.
And by PIP, Dick means no fault.
I'm using legalese.
Using the common term.
If I say PIP, it means auto no fault coverage. Thank you, Joe.
Yeah, no problem.
Now, what I will say to you, this, in my judgment, is the most complex change in the auto no fault law with respect to consumers who are buying or renewing automobile insurance coverage. I say that because whether or not you can do that, or whether or not the election you make is even effective, depends on your health insurance policy. And I will tell you that some health insurance policies are fairly clear. You can read it, you can understand that I have health insurance that covers injuries arising from an automobile accident. I can also tell you in my experience that many health insurance policies are as clear as mud. And it is extremely difficult for even lawyers and judges to work through health insurance policies that have not been drafted cleanly. And so understanding in your own health insurance coverage and whether it applies to an auto accident and injuries arising from an auto accident is extremely complicated in some cases. So beware if you decide to go down that road and to choose that option. Medicare beneficiaries can also elect to exclude auto no-fault coverage, shifting the cost for auto-related injuries to Medicare. And again, I will share with you that my father is Medicare eligible. When he renewed his auto no-fault policy, he called me and said, "What do I do?" And my advice to my father was, choose unlimited lifetime medical. Do not exclude. And basically, and we'll talk about this in a little more detail, and Joe has actually had some experience in some cases. Medicare does not cover every expense you might incur if you're in an automobile accident. It will be there to pay, but it won't pay for everything, exposing the Medicare beneficiary to expenses that are simply uncovered completely. And when that happens, your options, none of your options are good. So what does this all mean for you when you renew? Well, the word of the day is choice, and you have a choice. Our legislature, with these changes, they've decided that the people have spoken, and we are smart enough to make our own decisions about what kind of auto coverage to carry, and we will no longer be forced to carry unlimited lifetime medical coverage. And in exchange, if we decide to choose a lower level of coverage, we are going to see a reduced premium payment. That much is clear. But what I will tell you is, if you choose capped coverage, you're not choosing full coverage, and you are only partially covered for your injuries. That partial coverage has consequences. And these consequences really arise in two situations that I think we all understand. If you have medical expenses as a result of an auto accident that exceed capped coverage, what happens? And we'll talk about that. And I will share with you, just in our experience, if you have capped coverage and it's a serious auto accident, I've already said that, that will likely occur. Also, you may be an at-fault driver who causes injuries to someone who's decided to carry capped coverage. What that means is, if you are the at-fault driver, and God forbid you find yourself in that situation, but accidents do happen, and the person you injured has elected $250,000 in medical insurance on his or her auto policy, but in reality, their medical expenses are actually $800,000, that injured person, in many cases today now, can look to you, the at-fault driver, to pay those excess economic damages that they've incurred. They are now out of pocket because they've not chosen unlimited lifetime medical. They can look to you, the at-fault driver, in a lawsuit to pay their damages. That was never the case under the old law because we were all carrying unlimited lifetime medical. So you never, as an at-fault driver, would see a lawsuit filed by the injured person for the medical expenses that they've incurred because they would not have incurred those medical expenses. Today, those are on the table. And there's risk to you on the third party side that Joe mentioned if you don't carry enough liability coverage, third party liability coverage. So these questions that I'm asking, what happens? There's not a good answer. There are fairly harsh consequences if you're left exposed on either side of the insurance spectrum here. Let me give you one example, and we'll give you a couple more. Let's assume you choose on your auto policy $500,000 in cap. That seems like a lot, but as I've indicated, if you're in a serious accident and you're inpatient at a hospital for a month, you will go through those benefits quickly and reasonably so. Hospitals are in the business of saving lives and doing surgery and repairing broken bones. That's not an inexpensive proposition. Those benefits will be exhausted. And then what about other benefits when you're released from the hospital? You may need post-acute care. You may need to see your doctor for months. You may need physical rehabilitation. You may experience some residual effect of that auto accident for the rest of your life. And if you've only carried cap coverage, you will, I can almost guarantee for serious accidents, burn through that.
And let's talk about that briefly, Dick, because I think that's a really critical point for people to consider. You know, we have cases that run the gamut with some people that are in injured and minor fender benders where they don't require extensive care. Then we have people that have been in accidents that were so traumatic, they are still experiencing ongoing effects years and even up to decades later. And I think it's important as people think through this issue of when we used to set it up as unlimited lifetime, there was a reason why it was not only unlimited, but attached for your lifetime, because a traumatic event can be so acute and so serious for you or for a loved one that it can impact the direction of the rest of your life. And that's something that I think people, we talk about choice and that being the word of the day, that is exactly right. And people need to make an informed choice about the kinds of things that can happen if, heaven forbid, the worst should happen.
And so what would your options be in a situation like this? Imagine you've exhausted your $500,000 cap and there's another $500,000 in medical that you owe. We talked about this. If you're not the at-fault driver, you can sue the at-fault driver if there is one. Now, remember, many auto accidents don't involve at-fault drivers. They're single vehicle accidents, texting while driving, an accident where there's simply no ability to apportion fault among those involved. Not every auto accident involves an at-fault driver, but you could bring a lawsuit against that at-fault driver for what is called this excess economic piece, the additional medical you now have that you're responsible for paying because your cap's been reached. But as we've talked about, that suit really doesn't go very far if the at-fault driver doesn't carry liability coverage sufficient to cover your injuries and those damages. So, and we sadly see in our practice that very often is the case. You can pay out of your own assets if you have to cover these expenses, but I don't have that kind of money, and most people don't. For something like that, you would need to spend down your life savings. Unquestionably, that would be the direction many of us would have to follow. You could file for bankruptcy, of course, and try to discharge that debt, but new debt will be incurred if you're in the system, the medical system, for your lifetime, and bankruptcy is not a good option. Or you could try to qualify for Medicaid at that point, but to qualify for Medicaid, if none of you have ever experienced that system, what it basically means is you have to establish to the state of Michigan that you are medically indigent, right? You can't afford to pay your medical, but to get to the medically indigent level, you typically have to pay down all of your personal assets first. And worse, like Medicare, Medicaid does not provide the same level of care and the same level of benefits that auto no fault coverage would carry. Another example is opting out. What if you choose to opt out because you have Medicare and you think, if I'm in an auto accident, the Medicare system will step in and pay it? The reality of that decision, though, is for cases of major trauma, where you are going to need long-term post-acute care, Medicare, in many instances, will not cover those expenses. Medicare will pay up to some level and will cover some things, but it will not cover everything. Auto no fault does. And so it is not an apples to apples selection. I would say it's apples to onions, Medicare being the onion. And if given a choice, and you will be, and my father was, I told him, if I were you, Dad, I would choose the apple.
Let me speak to that briefly, because you alluded to this earlier. A recent case that I tried involved that very issue, where we had to ask the jury a question of whether or not these particular care provided was related to an auto accident. And what ended up happening in this particular woman's case was that she had Medicare available, but she also had auto no fault. She had unlimited at the time, because that's what it was. And the auto no fault carrier was saying, well, this wasn't related to the accident. Well, at the end of the day, Medicare provided 100 days worth of coverage for her long-term stay, and then it stopped. The benefit was essentially exhausted at that point for purposes of Medicare. That was not true for auto no fault. She was inpatient for a post-acute stay for a year and 2 months. And but for the fact that the jury came back and said it was related and said it was auto no fault, she would have been faced with a significant exposure for that benefit that Medicare didn't cover. So I would like to highlight this as a great example of, you think you got health coverage, but unless you know the details of what it is you have, you may not have what you think you have.
And then the final example that I'm going to discuss is opting out of auto medical coverage, auto no fault medical coverage, because you believe you have health coverage through your employer, for example. And most of us get our health coverage through our employer that will cover the auto accident. Well, I meant to say this earlier when I talked about the qualified health coverage opt-out selection, but I'm going to say it here. While our legislature was drafting the law that would permit you, a consumer, to shift or attempt to shift the cost of your auto injuries to your health plan, every health plan drafter in the state of Michigan was trying to amend its health plan to push back and to make sure that that didn't happen. And so my belief is that what your health plan said a year ago about coverage for auto injuries, it doesn't say that today. So you need to look very, very closely to determine whether you really do have health coverage for auto-related injuries through your health plan. But almost more importantly, your health plan only covers you as long as you have the health coverage. So serious injuries usually result in work loss. We know that. Very serious injuries typically result in the actual end of employment. And the end of employment universally results in the end of your employer-sponsored health coverage after you've gone through whatever applicable COBRA period might apply to that termination event. And so in the most serious auto accident cases, where you need your medical expenses covered most, it's likely that a point in time will come when you will no longer have health coverage. And when that coverage is gone, you're on your own. Very different than auto no fault, that if you choose the unlimited lifetime medical benefit cap. That auto no fault coverage is triggered and vests on the date of that accident and stays with you for your entire life if you make that election. It stays with you even if you cancel your policy because you can't drive as a result of the accident the day after the accident. You never have to pay another premium to that auto carrier because that coverage vests and is triggered and attaches to you or your loved ones for your life. And you don't have to worry about losing that insurance because it can't be lost.
Dick, we have a question here that I think is probably a pertinent time to answer it. One of our attendees asks, what if my employer's health care is primary on auto accidents? Is it acceptable to pick a $500,000 cap? I think you've answered that, but I think it's probably worth discussing briefly anyway.
Well, so what I would say is, in another slide, I'm going to say purchase as much auto coverage as you can afford. I mean, that's my advice there. But in that situation with that question, if you have primary health, is it appropriate to choose capped coverage overlaying that? It may be if that's what your financial situation allows you to do for your auto insurance. But what that means is you have health insurance as long as you have the health insurance. When that health insurance is gone, and if it's a very serious accident at some point in time, rest assured it will be, then your auto insurance, which is secondary, would step in and would pay up to that cap. So that means auto just will never pay more than $500,000, and it would be secondary to health. But for the most catastrophic injuries, that is not enough. If you're likely to lose your health because of the injury and you're going to get into that secondary capped auto, I would guess you're likely to exhaust that, and then you're going to be left uninsured going forward. Joe, do you agree with that?
I think that makes sense. The other thing I would add, Dick, is that remember, the scope of benefits available under your health coverage is very likely to be different than the scope of benefits available under the no-fault system. And that's an important thing to think about. I mean, every health plan is written differently. The employer has discretion. Does that employer purchase it through, say, Blue Cross? Does that employer create what we call a self-funded health plan where they draft their own document and decide what coverage is and pick and choose kind of from a menu? You need to have an understanding of the scope of your own health benefits for your employer and ask yourself, okay, is it broader, as broad? More likely, it's much more narrow than what the benefits you're going to have through the no-fault system would be.
So we've talked about choice. I'm going to mention it again. Today, when you renew, or if you've renewed, you had a choice, and you will have a choice. What do you do? What do you do with that choice, right? This kind of gets to the essence of what we're hoping to impart as part of this. Well, in my personal judgment, you have a choice, and I've given this advice, as I've mentioned, to my siblings, to my parents, to my adult children, to my friends. I'll give it to you. Purchase as much auto no-fault coverage as you can afford. Strive to choose the unlimited lifetime uncapped medical coverage that pays primary over any other potential coverage out there. It is still, in my judgment, the Cadillac of healthcare, and you should strive to purchase it if you can. You'll pay more in your premium than you would otherwise, but even today, you should pay less than what you were paying last year if you make that election. And if you're not, if you find that you're not, if you find that your premium went up, shop around. Go to other insurance carriers and price it. And my bet is you will find a carrier that will provide the unlimited lifetime medical benefit component to you today at a premium less than what you were paying for it under the old law.
We have a question here, Dick, that I think is probably relevant right now, which is Tina asks, if you do not visit your agent when you renew, what is the default setting? Unlimited? The short answer is it should be, and you should get paperwork in the mail that allows you to make elections, because the basic idea is that you will default to unlimited unless you affirmatively choose certain these capped or opt-out elections, and then you have to provide documentation to that effect. Now, the short answer there for anyone, and lawyers will always tell you, make sure to read your documents. Most of us, we go through life, we get a document put in front of us, we sign it, we don't think about it. Lawyers tell you, think about your documents. That's absolutely critical, because you're probably getting forms in the mail. I'd encourage you to read them, take them seriously, and make sure that your elections are consistent with what it is that you are after in the long run. If unlimited is what you want, I would look at your paperwork and make sure that it defaults to that, and then talk to your agents about making sure that you've made that election. Let's see here. All right, so we were talking briefly about this whole third party versus first party coverages. And this got to a point Dick had mentioned earlier. The possibility now that if the other driver caps his or her benefits, you may have to be responsible, if you are at fault, for his medical expenses. As Dick said earlier, that's something that didn't used to be the case, but it's become a potentially acute problem now. As more and more people make these elections, if they choose certain caps, the $250,000 or even the $50,000 caps, and if you get into an accident with them and you're responsible, they may look to you for those excess medical expenses. Now, that's where the other piece of your coverage is going to come into play. If you get your insurance, what we call the declarations page, which is just kind of the summary of the coverages that you get when you take out an insurance policy, it lists any number of things on there. It'll say, medical or PIP, and it will tell you if it's unlimited or if you elected one of the caps. It will also refer to this concept of liability coverage or third-party liability coverage. What that essentially means is it's coverage that you purchase in the event you happen to cause an accident and someone makes a claim or sues you. That protects you. It historically would have protected you from those pain and suffering threshold cases we talked about. Well, now, not only is it going to protect you from those pain and suffering threshold cases, but it's also going to potentially be used to protect you from excess medical claimed by the person that you may have hit. And so that is an important thing to think about. Your insurers are going to provide you with options, not only on your first party choices, your medical choice about how much coverage you elect for yourself, but also on your liability coverage. How much protection you are buying for yourself in the event that the worst should happen, that you hit somebody and they get injured. And that's where we mentioned here on the slide two types of things. We talk about third-party liability, which is those coverages that say, we're going to protect you in the event someone sues you. And then we also have what we call umbrella coverages. These are things that are sort of supplementary types of coverages you can purchase from your insurer. In my experience, they're actually fairly inexpensive. And I will tell you that for my own part, this is something that I purchased. I purchased third-party liability and umbrella coverage because I know now that the rules have changed. That not only have had the possibility of a lawsuit, but if I hit somebody, I have the possibility of them looking to me for their medical expenses. So I will pick for my own part. I talk to my agent, figure out what carriers are willing to write me coverage and at what levels. And then also, in addition to that, third-party liability coverage, we talk about the possibility of umbrella coverage.
And I'll add, at the risk that someone will listen to this and throw themselves in front of my vehicle, but I carry 1 million in liability coverage on my auto policy and a $2 million umbrella policy on top of that. So if anyone were to ask me what I carry, I would tell them that.
So, why we might as well answer this question here because it seems pertinent right now. Julie asks, if I elect unlimited on my policy and I'm sued as an at-fault driver, is my unlimited benefit affected for any future accident I may need for medical care? The short answer is no. Your unlimited goes to your own medical care. If you're in an accident, you can seek medical care and coverage for it, and that benefit should be unlimited. The liability piece, which we're talking about now, is a different animal. It's a different coverage on your policy, and it protects you if somebody else sues you. That's also what the umbrella coverage does. It's sort of a backup policy that you can decide, all right, I'm going to have, as Dick said, $1 million in liability and then maybe another excess umbrella coverage. Bottom line is, we'd encourage you to talk to your agents about the appropriate level of coverage for you under your unique circumstances. These are just important questions to be asking now that in effect, the risk to all of us has sort of increased for being on the road. We now have this new exposure that we didn't have before the legislature changed the law.
Just view it, there is just simply less insurance driving on the roads of Michigan today.
Exactly.
And where there's less insurance driving on the roads of Michigan and damages exceed the insurance available out there, someone has to pay that, and it could be you personally.
Exactly. So another thing to talk about, these are additional coverages, and we're sort of sounding like a PSA for insurance coverage, but because we do this work, we kind of understand the implications. Just something briefly to talk about with your insurance agents and have an understanding of are these concepts of uninsured and underinsured coverage. These are not mandatory. You don't have to get them. They're extra coverages you can buy from your carrier. And again, my experience, they're not that expensive. And they provide coverages in the event that you are hit by somebody else who doesn't have insurance. So use an example. We go out, or I'm driving down the road and I get broadsided. And I get all my medical benefits paid because I did the right thing in my judgment. I bought unlimited. That my medical is all taken care of. But I'm in the hospital for a month. I have horrible injuries. I end up having a leg amputated. I mean, you can let your mind wander on that, and it becomes a really, really painful endeavor. I may be frustrated and want to maintain a claim against the person who hit me, especially if, heaven forbid, he was a drunk driver. Well, if I do my due diligence and I investigate the claim, it turns out that not only was this gentleman a drunk driver, he didn't buy the mandatory insurance. In fact, he had no coverage at all. Am I out of luck? Well, not in this case if I had purchased uninsured motorist coverage. In effect, what I've done is I've said, all right, my insurance company, I want this supplemental policy, and you can pick your amount as to how much it is. And if I get hit by that uninsured drunk driver, and I'm out there and want to maintain a claim for my pain and suffering or excess wage or whatever it may be, I can do that through my own insurance company. Once I've shown that this gentleman that caused my accident was not insured at the time. So these underinsured and uninsured coverages are things, they're just supplemental things you can buy that will potentially provide you with additional coverages in the event that something like that were to happen. Bottom line there is you want to just have these in the back of your mind, consider whether or not you have them at all, and if so, how much. They may provide some supplementary coverages that would not be captured by the current system, but the bottom line is they're really there for your protection in the event that you are injured by somebody who doesn't have the minimum levels of coverage that they should. That gets us to a couple of things that we wanted to hit briefly. I know we're starting to get short on time here. One of the major changes that Dick mentioned at the front of our presentation was this change from reasonable charge to the fee schedule. And we're talking about this briefly because it has a couple of implications that folks should be aware of. As Dick mentioned at the outset, for the first 40 years, 50 years of its existence, roughly, the auto system in Michigan required compensation to the providers who provide you care for all reasonable charges that were incurred for your care. What that did was a couple of things. It made sure that the highest level trauma cases, which tend to be auto accident cases, and also correspondingly some of the most expensive cases to actually provide care for, that there was compensation to the system as a whole to ensure that not only were you getting the Cadillac of care, but that the system could sustain itself long term. Our legislature had made a change in 2019 that goes into effect starting here in July 2nd, where there's going to be, as Dick said, it's not really a fee schedule. It is in effect a cap on reimbursements. And it's changing potentially the scope of what, or it is changing the scope of what is going to be reimbursable under the no-fault system and the amounts. In many cases, it will result in drastically reduced reimbursements to medical providers. We foresee a couple of things that potentially happen here that may impact what the system as a whole and how it operates. One of them is that many providers, especially those post-acute long-term care providers, simply will elect or be unable to, for reasons of cost, to continue to provide either the fact of the service or the level of service that they were originally doing under the old system. We're already starting to hear rumblings of that in our context. And so we anticipate that that's going to continue to develop as this fee schedule or cap gets implemented. Another risk, and a particularly acute risk for folks to consider, is whether or not these caps are caps that are going to govern not only the reimbursement from insurer to provider, but whether or not the providers in some cases may look to the patient to recover the difference. The law is frankly not clear on that. And we expect that the courts will speak to that over time, but we also expect that many providers may end up looking to their patients for compensation to help them, frankly, maintain the level of care and even keep their doors open. These are consequences, and they may be unintended consequences of what our legislature did. For our purposes, that means, and for your purposes, that means that you may have additional exposure for out-of-pocket expenses if someone, for example, chooses that cap, or even frankly chooses unlimited, depending on where the law goes. My point in telling you all this is that having those third-party liabilities and even the UM and UIM coverages are a good, potentially prudent way to mitigate that exposure. And briefly, with respect to the last item Dick alluded to, which was the reasonable and necessary versus utilization review. Without going into the weeds on this, the risk that you're going to have going forward is that, as Dick mentioned, carriers will likely be more prone to question the type of care that you are receiving. And some of that may be a good thing for the system as a whole. Obviously, we don't want care being provided that's medically unnecessary. And that it does happen. Frankly, it happens very rarely in my experience, but it does happen from time to time. The real question for your purposes is, what does that mean for you? Well, if your carrier is saying to you and your physician, I don't think that's medically necessary, or I don't think that level of care is there and justified under the circumstances, and we're not going to pay it, then that potentially creates for you an out-of-pocket situation. It puts you to a decision about whether or not you're going to elect this care, notwithstanding the decision. So again, this goes back to where we started, or where we've been discussing throughout this entire presentation, of considering your various coverages is very important here, because you want to be able to access those other sources of coverage if in fact the circumstances can justify it. So we're pushing up on time here, but we do want to at least summarize a handful of things here for folks, just about what happens when the unfortunate happens and what do you do? Because we know that accidents happen from time to time. We see it every day. And so folks need to be thinking about what they need to do should the worst happen to them or a loved one. The number one thing is, of course, seek medical care. That's first and foremost. Wherever you are, seek, go to the emergency room, seek the care you need, and then you can start to consider how you respond to it. And there are a number of things that you can consider once you have done that and taken care of yourself initially. The general rule is you need to provide notice to your insurer. I know it seems basic and obvious, but that's the first step in protecting your rights. You want to, of course, notify your carrier, not only, that you were in an accident, but also the details of the accident, time and place, and the nature of the injuries you suffered. Better to do so in writing because it ensures that the carrier receives the notice that it's entitled to receive under the law. And that way, down the road, there isn't a dispute about whether or not proper notice was given. At some point, once you've given that appropriate notice, you're going to have some medical bills. And your providers may bill your insurance on your behalf. That's fairly routine. Some providers won't, and they'll send the bill right to you. You have, and the law requires, an obligation to provide what is called reasonable proof. It's really reasonable proof of the fact and the amount of the loss is what the law says. And what that essentially has been interpreted to mean is you have to provide your insurance company with copies of your bills, police report if it's available. And in some cases, you may have to give a statement or an examination if your carrier has specific questions. And usually they will let you know if they have specific questions or want to take your statement. Generally speaking, the easiest rule there is to be truthful. But if you have questions about what you're being asked, the bottom line is I'd say speak to an attorney because every situation is unique and every situation is different, requires its own analysis about what is an appropriate level of inquiry and what isn't. Generally speaking, insurance companies are required within the no-fault system to provide prompt payment. And that's once you've submitted your claim, depending on the timelines and all that, they have anywhere from 30 to 90 days to provide coverage for you. And then to process those claims to make sure they're being discharged for your providers accordingly. Sometimes that doesn't happen. And that's when you need to consider, what do I need to do if it doesn't? Well, if you take away nothing else from this presentation, take away the stuff on this slide. And that's where you've got three types of claims principally we've been talking about: the first party no fault claims, the third party liability claims, and the UIM claims. The first party no fault, you have 1 year from the date of the accident. Don't delay. Your claims can be barred. We have faced that kind of argument in the past. It happens. You don't want to be in that situation. Same thing is true for your third party claims. You've got 3 years from the date of the accident. Again, don't delay. And you may think 3 years is a long time, but frankly, working up a third party claim is no small matter. It requires an attorney to investigate, to do a lot of due diligence, to get a lot of background information. And it's not like you can just walk into court and file a lawsuit tomorrow. And the same thing is true with UM and UIM claims. It's going to depend on your insurance policy. So your policy will tell you if there's a particular time period that dictates when you have to act. Read those policies carefully. I know it sounds strange. I mean, even sitting here, someone who does this all day, who wants to read an insurance policy? But it's a good idea because it'll tell you what your rights are. And above all, talk to an attorney. You can talk to us. We're happy to have you reach out. But if it's not us, talk to somebody, because you never know what's going to happen if you wait too long. You don't want to prejudice yourself and prejudice your rights by doing nothing. Brief. Oh, we have some questions actually. Before we get there. Yeah. Thank you.
We do have some questions. We'll try to tick these off because we have about a minute or two. And
oh, Catherine asks, on my auto insurance, can I still elect primary or excess medical, or is it simply unlimited or capped? The short answer is you can still make elections about primary versus secondary. And if we weren't clear on that initially, the unlimited piece for your no fault is one aspect of it. So you can say, I'm going to make my medical unlimited, or I'm going to make it capped at the 250 or the 500s we talked about. In addition to that, you can still choose if you want your no fault to pay primary, even if it is unlimited, or secondary to your health. A brief word about that. One of the common disputes we see is where somebody elects secondary auto, and then they have a health plan that is not stepping up and paying as primary, because the health plan actually has language that says it pays secondary. One of our judges locally said, what was it, Dick?
He said, the only thing in America worse than having no insurance following a serious automobile accident is having two insurance carriers covering the same loss.
So the long and short of it is that, when you elect secondary, you are certainly within your rights to do that. It's a choice that we've talked about, but remember, choices have consequences. And when you choose secondary, you may find that you will have both your auto and your health fighting amongst each other, unable to resolve who should be paying your bills. And then you may end up having to, as the slide says, talk to an attorney.
I tell my family when they ask to choose primary auto no fault coverage for that medical component piece.
Gwen asks, how does short-term and long-term disability play into this in the event one cannot return to work due to an auto injury? It's fairly complicated. So your short-term and long-term disability is going to interact with the work loss, wage loss benefits you may have with the no-fault system, which means that there may be set-offs that can apply. The long and short of it is, I don't think it's that is going to dramatically impact anything we talked about today. You're still going to want to look to those unlimited benefits we've talked about and making your auto primary. But if you do have the situation where your short-term and long-term disability are coming into play, and you've got to intersect that with your auto no fault, you're going to have to look at your policies and see how they apply and whether or not auto is going to get a set off for some of those benefits.
And your wage loss on your auto policy is only for a period of 3 years. Your long-term disability may be obviously for a lifetime.
Last question we have here is from Jackie. Jackie says, what should my concerns if I volunteer for a nonprofit to drive clients to appointments? If I'm in an accident, can the passenger sue me if they get hurt? Well, Jackie, the short answer is yes, the passenger can sue you if you're negligent or if you somehow cause their injuries. So you have exposure there. The best thing I would say is you need to talk to your insurance agent, make sure you have appropriate coverages to protect you in that event. And you also maybe want to talk to the nonprofit that you're working with and figure out, does their general liability policy, or do their auto policies, do they apply to volunteers or do they not? Some restrict, some are broader. You have to sort of have those conversations and figure out, do I need to have my own insurance if I'm doing this? And what kind of insurance should I purchase? I think that's all the questions, Nick.
It is.
So just a quick preview for folks. We have 2 more webinars coming up. On Thursday, June 10th, we've got hiring your competitors' employees. And then on Thursday, July 1st, we've got cybersecurity 101. I don't know about you, Dick. I might attend that cybersecurity one. I'm not trying to hire my competitors' employees much, but that cybersecurity sounds pretty good. So in any case, thank you all for coming. If you have specific questions, here, we'll put our contact information there on the slide. Feel free to reach out to any one of us, either one of us. It's our pleasure to talk to you and help you through this if we can. We've been doing this long enough to know that it's a very, very complicated area of the law, and that it is deceptively seems simple, but when you dig into it, it's really not.
Thanks, everyone.
Have a great day.